Hello and welcome to Legal View. I'm Michael Ayala. Thank you so much for joining me today. I truly appreciate it. Today I'm going to take you through the motion for a new trial in the Karmelo Anthony case. Karmelo Anthony, he was a 17-year-old boy who got into a confrontation at a track meet. That confrontation turned deadly when he pulled a knife after being pushed by someone, stabbed that young man by the name of Austin Metcalf. And unfortunately, the knife went into the young man's heart and he died. Karmelo Anthony went to trial. He claimed self-defense. He was convicted by a jury and sentenced to 35 years in prison for the murder of Austin Metcalf. His defense attorney at the time, at the trial level, left the case. A new appeals team came on, a sort of who's who, and an all-star appeals team got involved of high-powered attorneys and appellate attorneys in the Dallas and Texas area. The original situation took place in Frisco, Texas. And they are now on the case. They filed a motion, a post-conviction motion for a new trial. Also, they filed a motion to recuse the judge, John Roach, who sat for the trial. That is the first thing that will be heard tomorrow. And I've already posted a primer on that to give you a sense of what the arguments are being made there. It is very simple. It's not whether Judge John Roach is too biased to sit and listen to whether he made mistakes at the trial level. It's really about whether his extrajudicial statements he made to the public, specifically in that interview that he did with a television station about the trial, right after the trial, if the statements he made there would put him in a position where a reasonable person could think that he could not be impartial when listening to that motion for a new trial. The idea is that the system likes to maintain public trust and give the perception of impartiality. So if you make statements, which they are encouraged not to do, but this judge decided to do it because he wanted to, quote unquote, provide transparency, then it's subject to this review. He refused to recuse himself, so they'll have that hearing starting tomorrow. Again, I go through all the statements that he made. I play those for you and talk about the chances of that motion for recusal. So take a look at that. It's up on Substack and YouTube as well. So you can look at that. Today, I want to go through the motion for a new trial. And again, this motion for a new trial is the first step in the appeals process. The way the system works generally in most states is that the original trial court maintains jurisdiction if a notice of appeal is given. And the first step is to give that trial court a second look at decisions they made during the trial and give them the opportunity to make corrections before it goes up to the Court of Appeals. And that's what this is. And so that's why the original trial judge sits and listens and says, hey, you made some mistakes. And as you can imagine, the judges usually, rule in favor of themselves and against that motion for a new trial, and it'll move on to the appellate stage. But because the judge has to hear it, that's why the motion to recuse is in place. So we'll see how that one turns out and who ends up listening to it. And I do want to say the court is up against some serious deadlines with these motions, because according to Texas law, the trial court has 75 days from when the verdict comes down to hear and rule on these post-trial motions. Well, the 75th day is the 23rd, which is a Sunday, so it moves on into the Monday. So Monday, someone is going to have ruled on these motions. Now, the motion to recuse will be ruled on right away because there has to be a determination made as to who's going to listen to the motion for a new trial, which happens the next day. So by the time that comes around, Judge Harl, who is the person who's sitting to hear the motion to recuse, will have to make a decision as to whether Judge John Roach or somebody else will listen to that motion for a new trial. And then if it is somebody else, the 75 days isn't told. It continues counting away. So that person, whoever it is, will have to come in, and it could be Judge Harl or it could be somebody else, but whoever it is has to get completely and utterly up to speed on the record of that first trial in order to rule on that motion for a new trial. So it puts the new judge in a little bit of a tight position because that has to happen by the 24th. Otherwise, trial court loses complete jurisdiction. The motions go away, and jurisdiction is then granted to the appeals court. And the defense team for Karmelo Anthony will begin preparing for arguments in front of the Court of Appeals. So it has to happen pretty quickly. All right, let's talk about this motion for a new trial. There are 3 grounds that the defense is claiming. Number 1 is that Karmelo Anthony was denied the right to a public trial guaranteed by the Sixth Amendment of the United States. This one is important because if it's found that he was denied the right to a public trial, the judge didn't follow the rules in the way he handled the ability for the public to see the trial, that is what they call a structural error. A structural error immediately grants a new trial. Other decisions, like evidentiary decisions, decisions on jury instructions, those have a secondary test called the harmless error test. If you made a mistake on evidence, for instance, the court then asks, was it serious enough to require a new trial, or was it, quote unquote, harmless error? It didn't affect the outcome of the trial to the point where we have to go back and do it again. But when it's a structural error, like the denial of a public trial, there's no such determination. It is immediately determined it is harmful error, and it's sent back for a new trial. So that one's important. The second one, of course, is the defense relied on a deal that was put forth by the prosecution to their detriment, and the prosecution reneged on that deal, and thereby denying the defendant a fair trial and the right to testify. The third one is that the court erred when they gave a provocation instruction to the jury to consider. The defense is claiming that they gave that an error because there wasn't enough evidence on the record for the judge to give that instruction to the jury. And the idea is that that instruction says to the jury, if you find that the defendant provoked the fight, then that defendant cannot claim self-defense. But it goes a little further in Texas law. At least that's what's claimed in the motion for a new trial. And I'll get into that as to why the defense believes that the court violated his rights, and the jury would then never have gotten the opportunity to consider self-defense with that particular instruction. And so that violated his right to a fair trial and should be granted a new trial. So those are the 3 grounds. So let's begin with the first one, that he was denied a fair trial under the Sixth Amendment. Now, I've said from the beginning here that the judge on his own, it's called sua sponte, when the judge does it on his own, decided about 10 months out from the trial that this was going to be a trial that was going to be conducted under the shroud of secrecy. He decided that there would be a gag order for everyone, defense, prosecution, the judge, people working on the trial, the court personnel, everyone could not speak or say anything about the trial. He decided that all motions, anything filed by any parties, had to go through his office, not through the normal channels, which would be public once they're filed, so that people can look at them and report on them or whatever, just keep track of a trial. The reason public trials are important is because you don't want things done in the dark. You want to keep transparency. And it's a right guaranteed by the Constitution. So the judge does all this on his own. He doesn't have a hearing. Neither of the parties made a motion to have all this done, to keep the secrecy of the trial. And the judge did it on his own for his particular reasons. I'm going to play for you his reasons for doing it. And these are important reasons. And they acknowledge that in the motion for a new trial. There's no question. But there are protocols to follow and ways to do it that they say were violated. And that's what's causing a problem here. Let's listen to the judge real quick.
And I'll tell you why. My primary goal in any case is to make sure that the defendant and the prosecution gets a fair trial, period. I have seen from other cases around the country where cameras in the courtroom changed the way that the judge acted, the lawyers acted, some of the witnesses acted, and we were not going to have that here. We were going to really isolate the purpose for which we were here for, which is to have that fair trial. And cameras in the courtroom did not enter into that equation at all.
So I have to ask.
All right. So that was the judge's explanation. And again, those are not uncommon. According to the motion filed by the defense, it's problematic on a number of levels. I'll start with, here it says, the first ground for new trial. The trial court violated defendant's Sixth Amendment right to a public trial by materially restricting public access to trial proceedings. And this is the key part, without the findings and alternatives required by Waller, Presley, and Stricker. Those are cases that stand for the proposition that if you are going to restrict public access, you need to put on the record why you are doing it. And that didn't happen in this case. They're saying he did not put it on the record. It says the court gave the general public only a 10-minute daily initial admission window, that roughly 24 seats for public observers in a nationally watched murder trial barred meaningful reentry during proceedings, provided no overflow room, no audio feed, no video feed for those foreseeably turned away. Once closure is shown, it cannot stand unless the record contains a Waller-compliant justification for those restrictions, and the existing record contains none. Nor does the danger end with this case. In a televised interview about a case that has drawn national attention, the court publicly defended these restrictions as a way to conduct a high-profile trial, describing the decision to bar cameras and streaming as an easy decision and stating that it had struck the balance pretty well. All right. So they're stating that the judge kind of did this on his own, did not put on the record the reasons. Not that the reasons were wrong, but that the fact that he didn't put them on the record as required by precedent to do that in order to restrict public access. Now, the judge will tell you he actually gave them access. All right, so listen to what he has to say here about seating in the courtroom.
Do you think there was a possibility for a learning experience? I mean, people do not know about how trial works. Do you think that this may have been an opportunity for people to know how it truly works, and that kind of erases some of the negative notions of court and trial?
I'm doing this
justice.
interview with you to make sure that people understand how the system works, and if they really wanted to, and I mean this seriously, if they wanted to, they could have stood in line with everybody else, and had the 27 to 32 public seats that we had in this courtroom that we rotated every day. And so, was that important to them? They could have made it in here. Like I told you before, as long as I follow the law, I sleep well at night. And I'm telling you.
All right, so there it is, the judge talking about the seating that he allowed in the courtroom. Now, he did allow a certain amount of public access. These arguments being made by the defense do have an uphill battle, but there is some law on their side. I want to go back to the motion now regarding what they say. And they say the order's findings cannot bear the weight the Sixth Amendment places on them. The court did recite findings. The case has generated substantial public and media attention, and that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial. But findings of this kind, this is what the defense is saying, are legally insufficient. They identify only generalized categories of concern, not specific concrete facts or articulated threat that Waller and Presley, and those are the precedents, require. And the word may, which is what was used, may, confirms that the court identified a speculative possibility rather than a demonstrated risk. The Court of Criminal Appeals rejected materially similar findings in Stedman, which is another precedent, where even detailed findings of heightened security concerns and potential juror discomfort were held insufficient because they were generic and identified no specific threat or incident. Findings specific enough that a reviewing court can determine whether the closure was properly entered are the linchpin of the Waller test, and generic findings will necessarily invalidate a closure. So that's the argument that they're making. And I really have no sense of which way this will go. It's hard to determine how a court may look at this. They go on to argue that when you combine the fact that the judge did this in terms of restricting public access to the courtrooms, that he initially had an overflow room for jury selection and then had no overflow room for the trial. The fact that he shut down anyone from saying anything about the trial, that he had all the motions coming through his office so the public could not have access to the trial. When you combine all those things, this was a trial that was really sequestered from the public. Did it go far enough to violate Karmelo Anthony's right to a fair trial? I want to take a look at another section here. The court's off-record sealing of the record was unlawful and harmed the defendant. So here's where they talk about the secrecy did not end at the courtroom door. It reached the court itself. Beyond the gag order that silenced the parties, counsel, and witnesses, the court directed that motions and subpoenas be hand-delivered to the court and held under seal. And the court, not the district clerk, served as the custodian of the case file. So that means the judge kept the whole case file, which was kept in chambers rather than in the district clerk's public file. No public order authorizing that arrangement, supported by the notice, hearing, and findings the law requires before the record may be sealed, was ever entered. The docket nonetheless reflects a series of orders restricting the record and in order to redact, et cetera, et cetera. So it's super important to understand what they're saying here is that, again, all of these were done not necessarily were they in error if the judge had legitimate concerns about witnesses, safety, protection, but you had to have specific reasons for them, which is why I go back to when I said he did all this on his own with no hearing. Neither party asked for it. Because in that hearing is where the concerns would have been made, they would have been put on the record, and the judge would have responded to those concerns by saying, this is how we're going to deal with those concerns. That would have satisfied the Waller test. Didn't happen here. Again, I don't know how ultimately in the trial for a new motion, I don't think it's going to pass that, but the appeals court, they take a look at that issue. It'll be interesting to see how they look at that. Right. Let's go on to the second reason for a new trial that they're claiming in their motion for a new trial. And that's the fact that there was this deal that was reneged upon, or at least according to the defense. Again, the prosecution has said they didn't renege on any deal. That was their understanding of the deal from the very beginning, that it did not involve Karmelo Anthony testifying. The way the defense goes about arguing this, they basically say that the second ground for new trial, the state's repudiation of the parties' unrecorded agreement, limiting character evidence after the defense relied on it, coerced the waiver of the defendant's right to testify and denied him a complete defense and warrants an evidentiary hearing. He goes on to say the agreement and the defense reliance. Santabello, which is one of those precedents, does not involve an identical procedural setting, but it supplies the governing due process principle. When the state induces detrimental reliance on a definite promise and then repudiates it after the reliance can no longer be undone, fundamental fairness is implicated. In Santabello versus New York, the state made a promise that the defendant relied upon, then broke it through a change of prosecutors, and perhaps inadvertently, the court held that the breach could not stand and vacated the judgment, even though the breach may have been unintentional and even though the sentencing judge said the broken promise had not influenced him. So they're citing that as one of the reasons. And it was stated in an affidavit by Mike Howard, and I believe agreed to by Bill Worski, the prosecutor in this case, that he was the one that came up with the idea. He went to the defense and said, basically, let's try this case. Let's try what he called a clean case. Let's not include any of the extraneous information about the victims and about the defendant. Apparently, based on police reports, when they did interviews with people at the scene, there were some negative things said about the victim in this case. They certainly had a background that suggested some things about them and their background that might have been something that would have been admissible. against them. The prosecution claims that they had 70 pages of social media posts and school disciplinary records. I don't know how it broke down. That apparently showed Karmelo Anthony had a fascination with weapons. So there was this inducement by the prosecutor saying, look, we won't do that. You won't go after our guys. Let's keep it to what happened under the tent. Those were those words. At least that's according to Mike Howe. That wasn't disputed by Bill Werschke. What was disputed by the prosecutor was that the understanding of what that meant. So Bill Werschke puts on his case. He's allowed to make a number of, I thought, objectionable questions, a number of questionable, the judge made a couple of questionable rulings that should have been objected to, and they weren't. And I began to question why. Are they throwing this trial? Turns out there was this agreement. So things that were said that should have been objected to, leading questions, perceptions that I thought could have been objected to, were allowed to stand. And the defense at that time was operating under the premise that we're not going to go after your guys when we cross-examine them. We're not going to cross-examine them on their statements to police, where they talk about the victims in the case and what kind of guys they were. We're not going to object when you're trying to get your information out. But they believed that that basically meant that Karmelo Anthony would be able to testify. Well, after the state finishes their case, and they had free reign to ask the questions they wanted to ask, present the evidence they wanted to present, came time for the defense's case, and they made clear that they intended to put Karmelo Anthony on the stand, and the prosecution said, whoa, wait a minute. The deal didn't include putting him on the stand. If you put him on the stand, I'm going to go after him. The problem with that is that now the defense can't go back and go after the victims in the case. People say, well, maybe the background of those guys wouldn't have been allowed in. But Texas has specific laws that might have allowed a lot of that evidence about the victims in. When there's a question as to who the initial aggressor was, and I think that was been a fair question here, then evidence of the victim's background can be brought in. I think the judge was quoted as saying when he had conversations with them that he didn't think it would be, but the argument would have been made, and one does not know. So at that point, Karmelo Anthony had to figure out, and his whole team, what we were going to do. They just finished their case. It was very damning. And if that's all you get, then a conviction was secured already. The defense had relied on that agreement. They didn't get experts. They didn't get anybody to testify about, and this was specific in their arrangement, although it was never codified. It was never put on the record. But apparently they had agreed there would be no experts brought in about teenage brains. Karmelo Anthony had epilepsy. No experts brought in to talk about how epilepsy might have affected the way he viewed the situation. And he wasn't going to get to tell his story. And the motion mentions the fact that they were only given 10 minutes to decide. The judge said, okay, realizing that there had been this misunderstanding, didn't say, okay, this is a problem. Let's adjourn for the day. Let's, let them figure out what they're going to do. None of that. He gave them 10 minutes to go figure out and decide what they were going to do. Now that the main crux of the defense's case was basically vitiated. They were just going to put Karmelo Anthony on to tell his story. So the prosecution is arguing, as a result of this, that violated Karmelo's right to a fair trial. Listen, you and I all feel it. I think anyone who listens to this has to say something's odd, and you feel like it violated his right to a fair trial. But that's not enough. The appeals court has to look at it. And the problem, I think, for this particular claim is that appeals courts don't look back at strategy, right? You don't want the appeals court to look back and say, well, the defense attorney made some bad decisions, and that's really the problem here. Okay, let's do this again. Doesn't do that. And I think the decision to enter into this agreement, the decision to not put it on the record, which I don't understand why the defense didn't do that. To be honest with you, I don't understand why the judge didn't demand it and the prosecutors didn't do it, because we're not talking about these little agreements. Attorneys make agreements all the time. Little agreements here, little agreements there to help smooth the trial along, get it through. But when we're talking about an agreement that involves a constitutional right, the right to testify, you want that on the record. Now, I don't fault the defense because in their mind, it didn't include his right to testify. But the prosecutor, if he's saying that, from the very beginning, it included his right to testify, then he should have wanted it on the record to protect himself. Because he was, in essence, denying with this deal the right of Karmelo Anthony to testify. So there is a lot for the appeals court to consider. Now, I am jumping to the appeals court because I don't think this is going to pass muster at all at this level, the motion for a new trial. It could very well. I don't see that happening. I see this going to the appeals court and maybe them taking a look at what happened here. So there's that. The third one is an interesting one because it implicates jury instructions. And it was an issue that I felt existed at the time throughout the trial. I said from the beginning, from opening statements, the prosecutor said, and it became clear when they asked for the provocation instruction, why he took this tact. But I thought it odd in opening statements that he's talking about from the moment Karmelo Anthony left the house, he put that knife in his bag because he wanted to kill someone that day. He woke up wanting to kill someone, left his house wanting to kill someone. He went to that tent looking for someone to kill. And he started to provoke everyone when they told him to leave the tent, not because he was a teen being stupid, not because of teenage bravado, not because it was raining and he's like, y'all telling me to leave and want me to go back in the rain. That ain't happened. None of that. Because he wanted to kill someone. And I said from the beginning, where is he getting this? Where's the evidence to suggest that was the case? Are there text messages? Is there notes? Are there something he said to someone that you're putting in his mind the idea that he went out that day with the purpose to kill? It seemed odd. And then every witness that took the stand, he continually asked the same questions and at times leading them. Karmelo Anthony was the sole aggressor, right? Yes. Karmelo Anthony provoked the whole thing, right? Yes. Those are leading questions that the defense, had it been a straight trial, would have been objecting to. Let the witness talk about what they saw. You're giving them the words to explain what they saw. It's not appropriate when it's your witness. It's fine on cross, but not on direct. So they were aiming for this provocation. And basically, their claims went uncontested because they had made that deal. So they got away with it. But still, the defense is arguing that even with that testimony I'm talking about, it wasn't enough to support a provocation instruction to the jury. And the reason, because there are statutory requirements before you can give that provocation instruction to the jury. And they cite them in their motion. They say in order to give the provocation instruction, and let me step back for a second and explain why it's problematic. Because if you give them the provocation instruction where you say to them, if you find that the defendant provoked this for the purposes of creating a problem so that he could kill the person, then they don't get the right to claim self-defense. So what the defense is saying is that by giving them that instruction, you precluded them from ever considering the self-defense. And if you gave it to them in error, then that's problematic. They never would have been able to consider self-defense with that instruction because it was clear from the way the case was presented that he provoked it. And so self-defense is out the window and they never considered it. But they should have been able to consider it because the provocation Instruction should not have been given. And here's the reason they give. The law in Texas, according to the motion by the defense, it instructs the jury, if you find beyond a reasonable doubt, this is the provocation instruction, if you find beyond a reasonable doubt that the defendant intentionally provoked the victim into using force so the defendant would have a pretext to harm them, the defendant forfeits the right to claim self-defense. The defense is challenging this, saying that there's a three-pronged test, three things that need to be met before you can give the provocation instruction. Number one, that it was intentional pretext, that the defendant did or said something calculated to provoke the victim. Can we say that under the evidence in the case? I think it's fair to say that Karmelo Anthony, according to the testimony, was saying some pretty nasty things to the people under there. Was he trying to provoke them? Was he just being loud? I don't know. But if you want to interpret that as being provocative, fine. I got no problem with that. The second one is the direct causation. The defendant's act actually provoked the victim into using or attempting to use force. I don't know how fair that is to say, but again, the questioning by the prosecutor made clear that that was the case. Not sure that that was actually the case. But if you look at the video, the way the young men went right up to him, he's in there. He was called over by a friend. This is Karmelo Anthony. He's talking to the friend. So he didn't go to the tent looking for trouble, first of all. I think that alone makes it questionable as to whether he went to the tent or went looking for somebody to kill that day. He wouldn't have even went to the tent had his friend not called him over. The friend tried to claim he wasn't a friend on the stand, but he was his friend. And then he starts getting into it with the folks there. Okay, fine. Then these guys come into the stadium and they're kind of the enforcers, right? They're the guys who look out for folks. They're a little bigger than everybody else. They're the athletes, football star. And they go right up to Karmelo Anthony. 4 kids, you can see it in the video. They tell him he got to go. I'm not, you got to get out of here. He says, no, don't put your hands on me. He tells them, don't put your hands on me. I'm not sure how that plays into the idea that he is actually trying to provoke them to do something to him. Maybe it is, maybe it isn't. Again, reasonable minds can differ. Argument continues for another few seconds. He puts his hands in his, according to testimony, puts his hand in his bag and says, touch me and find out. I think like, what are you going to do or something? And he said, touch me and you'll find out. So again, here he's trying to tell them, don't touch me. This is one of those things when we talk about how race plays into cases. Black people, when they say don't touch me, they mean don't touch me. I'm not telling you don't touch me because I want to stab you. I'm telling you, keep your hands off me. Don't put your hands on me. Right? That's how I interpret it. Now, again, the jury was not from where he's from. There were a couple of ethnic people on the jury, but not black people. They were excluded from the jury very early on. And so when you hear that, you can buy into the fact when the prosecutor is telling you that he said that to provoke him into pushing him so he could stab him. I don't see that at all. And again, that's not being unfair. That's just understanding culture. That's why you need a jury of your peers. That's why some black people should have been on that jury. Now, who's to say that any of those teachers that say that were kicked off would have seen it that way? But I think people would have felt better if they had heard it and then said, look, we don't buy it. We think he was provoking him to stab him. So that's the second one. And the third one is pretextual intent. The defendant provoked the victim specifically as a pretext to kill or seriously injure them. Again, they're claiming that there's no evidence to support that. There was evidence that he provoked them, but you got to meet these standards, that he provoked them specifically as a pretext to kill or seriously injure. And the defense is saying, where's the evidence of that? And I said that from the very beginning when I heard it in opening statements, when I heard it in closings. I said, where's the evidence of that? How are you getting from point A to point B? That confrontation was provoked by Carmelo Anthony in order to provoke Austin Metcalf to mess with him just so he could kill him. He had a 3-inch knife in his bag. We don't know why it was in the bag. We never got to hear why it was in the bag. What if he had testified and said, gosh, I used that to clean my cleats a couple of games ago, or a couple of track meets ago, and it was just in there? How does that change the narrative that he just wanted to provoke him to kill him? Maybe it does, maybe it doesn't. But I didn't see any evidence of an issue between the two of them, a reason why he would have wanted to kill this boy. I think he was there for whatever reason. He was being obstinate. And when these guys came up, they weren't playing no games. Fair enough. Carmelo wasn't playing no games. They clashed. Because Carmelo had a knife, it ended in death. Now, I'm not saying at all Carmelo Anthony shouldn't pay for his crimes. But I say two things. One, let's get all the facts out. Let's have a fair trial. And two, let him tell his story. That's part of all the facts. That's part of a clean trial as far as I'm concerned. And you say, I want to just keep it to what happened under the tent. I got to hear what Carmelo has to say. So the fact that the prosecutor would think that that didn't include Carmelo, it boggles my mind. But that's what he said. So that's what the prosecution, that's what the defense is claiming here. Those are the three grounds that will be heard in Thursday's hearing and motion for a new trial. As far as witnesses, there will be witnesses called. I believe one of the court clerks I know is on the witness list. I have not seen the witness list, but I know it was reported that one of them is on the list. And again, they're going to testify to the actions taken by the judge on his own to restrict public access to the courtroom for whatever his reasons. They'll argue again that they relied to their detriment on that deal with the prosecutors, and they'll argue that they did not follow the rules when they gave that provocation instruction to the jury. So again, just to reiterate, by giving that instruction to the jury, it precluded them from ever considering self-defense. If you don't give them that, then they could have considered self-defense. Now, this is one of those things that does get the harmless error treatment. It's very possible, based on the way the trial went down, if this is the one that they find was problematic, you take a look at it and you say, was it harmless error? By giving them this instruction, did it materially affect the trial? Would the trial outcome have been different had they not given the instruction? I'm not so sure it would have. I'm not sure, because of the evidence in the case, the way it played out with this whole deal thing and his not ability to testify and bring in evidence, the self-defense thing would have worked anyway. So it's very possible it may be considered harmless error at some point if it makes it to the appeals court. So there it is. That is the motion for a new trial. That will be argued Wednesday. Hopefully that gives you a little bit of a clearer view as to what will be argued. I still say it's a very low percentage. And look, that's not going out on a limb. Appeals in Dallas are only successful about 4% of the time, and that's at the appeals level. This is the still at the trial level, the post-conviction motions. I don't have statistics for that, but I've been around this game a long time. These do not get granted very often. Again, it's just an opportunity for the trial court to look at their decisions, look at what's being argued, and just double check that they feel they did the right thing. And most judges are. How many judges are going to say, oh, you're right, I made the wrong decision? Especially a judge who went in the public and said, hey, I followed the law to a T. Everything I did was right. I would not be surprised, though, if that motion to recuse is granted. I wouldn't be surprised, because they do not like judges that go out and make those public statements. And in that interview, the judge said the reason he was giving it was to provide transparency, which is the oddest thing to me. If transparency is important to you, the ultimate transparency is letting cameras in, let everyone see the evidence, let everyone see the testimony. But no, you lock it all down completely and utterly, and then You decide that you're the one that's going to provide your perspective, your words is going to be the thing that provides transparency. That's not transparency. That's a point of view. You gave your point of view. So anyway, it'll be interesting to see. I'll be following this. This is one that's really interested me, and I just want to keep on top of what's going on here. And again, I've never said that Karmelo Anthony is not guilty of something. I think he probably might be. Again, I need to hear from him. I need to know why he had the knife. I need to know what he was thinking, what was going on through his mind. All those things to determine whether self-defense might apply, whether he was fair to fear for his life. He was clearly surrounded by 4 fellas who outweighed him probably double his weight. So I'm not going to say self-defense wouldn't have flown here, but bringing a knife to an argument like this when everybody else is unarmed could be problematic. So I don't know. But let's have a fair trial. And that's basically what they're saying here at this level. All right, folks, thank you so much for joining me. I want to remind you, if you're interested in learning more about the motion to recuse, I've already posted something about that. That's up on YouTube and Substack. This will be going up on YouTube and Substack as well. We'll be covering some of this stuff as well in Make It Make Sense. And again, they all fall under the Legal View umbrella. Legal View is the broader umbrella. I do In Session with Judge Ashley Wilcott. And I do Make It Make Sense with Marie Pereira, where we sort of take a little different approach to some of the legal issues and cases going on in true crime. So again, thank you so much for joining me. I'm Michael Ayala, and this has been Legal View. Have a fantastic day. This is Legal View, where we look at the news from a legal point of view.